Rights Center of Pretoria and the three generations on digital human rights. So today's session will border on very pertinent questions that have come up as a result of looking at how artificial intelligence can be governed in a way that approaches human rights and looks at it from a human rights perspective. We are going to be looking at important things like how we can go about creating an AI Bill of Rights for artificial intelligence and what that would look like. And to officially open the session, I would like to welcome our distinguished speakers to give us the opening remarks. I will begin with Honorable Commissioner Garisha Uvena Topsi-Sono, and this will be followed by Dr. Sabelo Gumeze, who is an Assistant Director at the Center for Human Rights at the University of Pretoria. Following this, my colleague Salam will give us a brief overview of what the panel discussion will be like. And yes, we're looking forward to a very interesting conversation today. So please, Salam, sorry, Honorable Commissioner, the floor is yours.
So good afternoon, everyone. Thank you for being here today for this important conversation we're going to have about AI and maybe human rights aspect. So as you all know, there is a very growing reliance on AI in our society these days. AI has many positive impacts, namely on the provision of health services, labor safety, transportation, education, due to the accuracy of AI systems. However, there are also negative sides to the AI system, and these put human rights principle under pressure. Governments may be using profiling systems of AI to encroach on the right to privacy. The lack of transparency of the algorithm decision-making process of the AI systems also pose problem. Access to AI systems, data protection, algorithmic bias, algorithmic transparency, manipulation, human interaction, as well as accountability are all emerging threats which have to be dealt with within our society. In Africa, AI systems developed so far do not take into account the native languages, skin tone, and overall African context. This results in discrimination and bias. Data issues are also prevalent. Major companies involved in the development of AI do not, up to now, think that the human rights aspect should be integrated in the development, use, and mechanisms for any redress mechanisms. So these have to be, we should continue to have major conversations with these companies that are developing AI. The Commission has had a study on AI, robotics, and other new and emerging technologies in Africa. As Commissioner Derso was the head of that study, he can tell us more about the study later on. So as Special Rapporteur for Freedom of Expression and Access to Information, I am aware of the numerous problems with the development and use of AI, and we'll be looking at ways and means to address the human rights aspect in an appropriate way with the Commission. Thank you very much for your attention, and I look forward to very meaningful discussions on the topic. Thank you.
Thank you very much, Commissioner, Program Director, Honorable Commissioner Deso, who's present here. Distinguished delegates, and for those who are also joining us virtually, greetings to you. We bring warm greetings from the University of Pretoria Center for Human Rights. and we extend our sincere appreciation for all the partners who are here for partnering with us in this important exercise. We meet today at a very critical moment. Artificial intelligence is rapidly transforming our societies, and it presents both significant opportunities as well as serious human rights challenges, particularly around equality, accountability, dignity, as well as justice. I think the commissioner has already elaborated on some of these challenges in her speech. Ladies and gentlemen, today's discussion is very important for us because it brings together two key initiatives. The first being the Oxford White Paper on International AI Bill of Human Rights. And the second one speaks about the African Commission's own initiative on the study of AI and emerging technologies, which Commissioner Deso has been leading on. Together, these initiatives reflect the need for us to align global as well as African perspectives in shaping rights-based AI governance. And the central question before us is very clear. How do we ensure that AI systems are designed and governed in ways that uphold human rights and that effective safeguards and remedies are in place? The African human rights system has a vital role to play in answering these pertinent questions. And it can actually do so through an appreciation and an understanding of its own norms, its institutions, and most importantly, its evolving jurisprudence. We do hope that today the dialogue will contribute to a shared inclusive vision of AI governance that is firmly grounded on human rights. I take this opportunity to thank all those who have actually made a contribution to this debate and that will also continue to make a contribution to this very important debate. It therefore pleases me today to thank you for your attention and also to wish you a productive discussion. Thank you.
Thank you so much for the wonderful opening remarks. Welcome again, everyone. I think we have more folks who have joined us in the room today. My name is Salam Abdallah. I am a researcher at the Global Center on AI Governance, and I'm just going to give folks an overview of the presentations to expect in the coming couple of hours and also the panel discussion that these presentations are going to be grounded on. So first, we're going to have a presentation from Honorable Commissioner Salamon Ayala Derso on the Human and People's Rights draft study on human and people's rights and artificial intelligence, robotics, and other new and emerging technologies in Africa. And that is going to be followed by a presentation of the white paper, An International AI Bill of Human Rights by Professor Yuval Shany, who prepared this proposal for an AI Bill of Rights under the Accelerator Fellowship Program at the University of Oxford. After which we will have a panel discussion, which would include the commissioners who have joined us today, as well as expert panelists to discuss the implications of the draft study, as well as the proposed AI Bill of Rights and what that means within the African context. So without further ado, if I may welcome Honorable Commissioner Salamon Ayala Derso to speak to the draft study on AI and human rights in Africa. Thank you.
A very good afternoon to all of you, ladies and gentlemen present here today. I would like to thank the organizers of this event for the kind invitation extended to us, myself and Commissioner Topsy Sono, to be part of this important conversation that we are having on the sidelines of the 87th ordinary session of the African Commission on Human and People's Rights. I also wish to acknowledge the Center for Human Rights for the collaboration that was critical for the development of the study that is currently being finalized by the African Commission on Human and People's Rights for presentation and its adoption by the Commission. I understand and I see Thompson online with his presence. It means that I will leave a lot of the responsibility on addressing specific aspects of the study to him. I also need to join back the session since I need to deliver my intersession report this afternoon. Now, both Commissioner Topsy Sono, but also Dr. Sabelo highlighted the significance of the technological developments that human society is experiencing at the moment, particularly in terms of AI and digital technologies, that the pace of the technological advancements is not in sync with the pace of development of guardrails for ensuring that the benefits of these technologies would be available to all mankind, humankind, and the risks of these technologies also is minimized as much as possible. And that can only happen if both, as Dr. Sablo mentioned, the design and development of these technologies is actually grounded in and is guided by basic standards of human rights. That is a prerequisite for us to ensure that the benefits actually are as widespread to all as possible and the risks are mitigated. It is in the context of the appropriation of these technologies on the African continent and their deployment across different social public domains and the emergence of various incidents relating to the deployment and use of these technologies. As Commissioner Topsy Sono mentioned, algorithm bias and the kind of misinformation, disinformation, deepfake that started to cause harm to various sectors of society. We have these actually accelerating certain negative tendencies, whether those are, for example, issues relating to hate speech, issues that actually accentuate and accelerate incitement of violence, and in some political contexts leading to actually very dangerous outcomes affecting the lives of people who are caught up in these situations. And some of the prejudices that we have in societies get incredibly accentuated and become really hugely their impact becomes deeply pronounced when they are actually taken to the digital space. I think that has to do with the fact that when we are in a social setting, there is a certain level of restraint that we tend to show. But when we are in front of our there is no restraint whatsoever. So we get to say and do stuff that we ordinarily do not do. And how do you actually address those things? Because they have real life consequences, including particularly for vulnerable groups, minorities, women and girls, the kind of negative consequences that they are facing. And in different domains as well, such as the military domain, there are concerns about the deployment of certain automated military weapons, whose consequences would be very devastating. I think we already are alive here in Africa, how the emergence of drones, other weapon of choice, is completely transforming wars and conflicts on the African continent, with increasing threats of these weapons being used and accessed by very dangerous actors as well, with all the consequences relating thereto. And it is against this background that the African Commission on Human and People's Rights adopted a resolution 473, 2021, on the need for undertaking a study on human and people's rights, and artificial intelligence and other new and emerging technologies, digital technologies as well. And this resolution basically highlights the kind of issues that the study is expected and needs to address, particularly identifying how the rights and freedoms enshrined in the African Charter, in their fullness, civil, political rights, economic, social, and cultural rights, and collective rights of peoples, and the values that underpin the African Charter, including the commitment to collectives, as we know, can be deployed in a way that would enhance safeguards in terms of the process of appropriation and adaptation and deployment of these technologies on the African continent, but also the kind of roles that the African Commission on Human and People's Rights and its special mechanisms can play in the delivery of their responsibilities across the protection mandate that is provided for in Article 45 of the Charter, the promotion mandate, and the interpretation mandate that the African Commission on Human and People's Rights has, of course, complemented by the protection mandate of the African Court on Human and People's Rights, and that complementary relationship that exists. And beyond and above that, of course, the collective responsibility that states have, not just individually, but also collectively, as far as the measures that need to be taken, not just at the national level, but collectively, on account of the fact that the development of these technologies are being carried out by private actors residing in advanced countries and away from the African continent. But of course, increasingly, we are also witnessing some of the operations being carried out here on the African continent as well. And how do we therefore have a collective measure on the part of African states collectively, because that is one of the unique features of the African Charter in terms of recognizing that collective responsibility of states, not just vis-a-vis what happens within their jurisdiction, but also in addressing things that are beyond the control of individual states. And this is one of those instances in which that collective responsibility would be invoked and applied to. And therefore, the kind of enormous level, a higher level of responsibility that African states have, particularly given the limited role that they have, at least until recently, with respect to the development of these technologies. At least the role and responsibility that they have for the development of the governance system at a global level, because of the vulnerability of Africa becomes higher, and therefore the need for addressing those issues. And we have had the opportunity of working with the Center for Human Rights together with Professor Changeta and a wide array of experts in the development of this study, which has now been, the drafting has been finalized. We will do in-house work in order to make it ready for the African Commission's consideration and adoption. And it's my hope that the next session of the Commission would be when we would be presenting it. And I hope by then the Commission would give its go-ahead and we would have the final copy of the study out, shaping and informing both policy considerations, academic and civil society discourse, but also, I think, legal development on the African continent. Later on, unfortunately, I will not stay for the panel since Changeta is there. I will leave the rest of the discussions on the draft in his good hands. Once again, I would like to thank the organizers of this event. I see quite a heavy presence of my compatriots in the house, which is a delight to see. Active role being taken by Ethiopians. So my absence wouldn't detract much because of them as well. So thank you very much once again. I wish us all a very productive deliberation. Thank you.
Thank you very much. This is really a wonderful opportunity to be here, and I want to thank all those who have contributed to organizing the event. The Center for the Global Center for AI Governance, the Pretoria University Center for Human Rights, of course, the Commission for Human and People's Rights, and I'm very grateful to see the commissioners and other stakeholders here. My institute at Oxford, the Oxford Ethics in AI Institute, and also the Three Generations of Digital Human Rights, which is the ERC, European Research Council sponsored research project that in a way started all of this for me. Just in terms of my, quickly on my background, I was for 8 years a member of the UN Human Rights Committee in Geneva. And during early 2013 till late 2020. And these were quite formative years for human rights and technology, because these were the years in which some of the big issues concerning abuse of human rights through technology had arisen on the global horizon. Surveillance cases relating to surveillance came our way. Cases relating to lethal autonomous weapons were coming our way. And the committee was struggling using its collective maybe expertise in international law, but very limited experience in actually dealing with human rights and technology to try to address some of these issues. We were actually quite helped with regard to lethal autonomous weapons by the work of the African Commission. Christoph Heinz, who was a member of our committee, but was also consulting the African Commission on General Comment number 3 relating to the right of life, helped us at least get some initial ideas on the table. But even when I left the committee, I continued return to my academic work, I was convinced that this is an increasingly dramatic area where, in a way, the future of human rights lies. And if the human rights movement would not be able to be agile and address effectively these sort of challenges, given the speed of the technology, human rights will be left behind. And I'm afraid that we are playing catch with technology, and I don't believe that the human rights actors are prevailing in this competition because the technology is moving very, very fast. And so we were concerned at the time with social media, but of course now we have generative AI, and people are talking about artificial general intelligence and agentic AI. And super intelligence. So the technology is running very, very fast. Human rights is not up to speed. And my second observation was that the treaties that we have that were created in the case of the UN in the 1960s, in the case of the African Charter in the 1980s, they would need to be somewhat adapted, either through interpretation or through the generation of complementary standards, as we do, in many areas. Actually, the African system had been quite successful in developing additional treaties and additional concept on human rights to deal with the needs of special groups and also with special human rights challenges. And there would have to be maybe my research hypothesis when I started the research project that we should be thinking as to whether we would need, how much can we rely on existing standards in this field and how much we may need to complement them with new standards. And the project that I was working on at Oxford was specifically on this issue. Do we need an AI Bill of Rights? And for 2 years, I have worked there and doing a lot of library research, but also a number of high-profile consultation with stakeholders. We did one consultation in Pretoria, and we did one consultation in Geneva, and we did one consultation at Harvard, and we did one consultation at Oxford. And we have brought around the table many stakeholders from academia, from human rights activists, from the actual people who are actually officers for human rights institutions. We also had some representatives of technology companies in some of these consultations. And the white paper, which was published late last year, is the cumulative result of this effort. And I was very pleased to see the parallel move that the Commission here has taken on creating the draft study, which addresses a lot of these same issues. And I feel at least personally, I feel somewhat validated that many of the conclusions that I have reached through the ad hoc process that I orchestrated were also reached by the Commission through its perhaps more structured approach to the issue. So, yeah, I just need to get the slides moving. Yeah, okay, good. So I'll go, I don't want to take away time from the panel, so I'll try to go through my points relatively quickly, and maybe if there is time, we can discuss it during the panel session. But the first point that and again, you see here a parallel to the draft study. There is a part of my white paper has a mapping element to it, and it tries to map what are the disruptive effects of AI technology that could have human rights implications. So whereas the draft study looks at the different rights and takes it a right-by-right analysis, which is extremely useful, my approach was to try to actually study the technology and try to understand what features of the technology of AI systems could create problems from a human rights point of view. So issues of speed, the speed in which systems operate, questions relating to safety and quality. The commissioners spoke before about data collection, massive data collection as a game changer with regard to human rights and new technology. Discrimination, opacity, of course, these are all issues that all of us know. But the point that I was trying to convey through this part of the white paper is that the disruptive effect of AI technology has significant human rights implications, not necessarily negative human rights implications. There are certain aspects where speed could actually be, in certain contexts, very useful. And the draft study also makes the point that if one wants to quickly intervene in a law enforcement context in order to protect individuals who are at risk, speed could be actually quite useful. But as we know, there is also a dark side, and we would need to be mindful of that dark side as well. From then, the paper goes to identify. Sorry, it's moving in a purpose speed. It's moving in a speed of its own. It then identified certain areas where at least the conclusions of the white paper and the consultation is that with regard to some areas, we do not have major problems because we do have certain rights which are quite flexible, such as, for instance, the right to life or the right or freedom of information that could serve as very useful frameworks to review the application of AI systems, and to from the text that already exists, we could actually construct through practice, through interpretation, the guardrails that were mentioned before, so that we are able to enjoy the benefits of AI systems while avoiding some of the risks. And many human rights actually fall in that category. But there are some rights in which we need to introduce some more granular engagement with the text and identify specific problems which need to be given expression so that all stakeholders, including the technology companies, but also domestic regulators and human rights victims, would have the necessary vocabulary available in order to identify, for instance, the problem of proxy data as a problem that creates new categories of discrimination that go beyond many of the traditional categories that we have in our case law and sometimes in our treaties. So there are certain aspects relating to the technology that may benefit from increased interpretative expression, like a general comment or a declaration or a statement that would give everyone in the field more specific guidance as to how to operate. There are certain elements where we need to be cognizant of the fact that the disruptive effect of AI systems in certain areas implies that traditional safeguards that we have developed in practice, for instance, anonymization or encryption, those safeguards may no longer be useful in a world where AI systems are able to circumvent these safeguards, or certain distinctions that we have in traditional understanding of privacy, such as distinction between data and metadata, or privacy in public and privacy in private. These distinctions have to be reconsidered. So the disruptive effect of the technology means that we sometimes also have to reinterpret our existing rights in ways which differ from the ways in which we have interpreted them before. And then, and I'm reaching the final part of this stage of the white paper, there are certain areas where the introduction of AI systems fleshed out some human needs, some basic human needs, some basic human interests that the human rights movement traditionally didn't engage with heavily, and didn't develop very clear standards as to how to deal with them. So one area is the issue of transparency and explainability. Of course, we all know that transparency is important. And in many of our work in human rights, we speak about transparency and accountability. But here we have systems that are almost by definition non-transparent and almost by definition non-accountable. So not only the integration of the system, but the increased reliance on the system requires us to think maybe it's time for us to identify transparency, explainability, accountability as human rights, that we actually want to give them a name so as to empower victims of non-transparency, victims of non-accountability, to use it in a more direct and maybe a more effective way. The slide here also talks about manipulation, which is another area where manipulation is not new. We've always had manipulation. I've said it in a previous meeting we've had in Pretoria a couple of weeks ago. I mean, politicians would be out of work if there was no manipulation. and also some advertisement agencies. I mean, the idea of manipulation is there, but we never considered this as a serious problem until the age of AI. Now you have those systems that could actually manipulate us, not only at scale, but they can also identify very easily for each one of us what are our cognitive biases, what are our vulnerabilities, and to adapt for what are our preferences, and to adapt for each of us a package which indicates which buttons need to be pressed in order to move us right or left, to have us buy something or have us vote in a certain way. And this is a threat level that we have not seen before, which may require a response from the human rights movement through the development of standards that so far were relatively dormant. Another example which was mentioned by the commissioner is the idea of interaction, human decision-making. Again, before AI came to the picture, there were very few instances where we interacted with intelligent machines in relation to very important topics, in relation to actually upholding our rights. But this is changing. And we have to ask ourselves, do we expect a world in which machines take important decisions regarding us? Machines, actually, we interact with machines in a hospital, we interact with machines in a university, we interact with machines when we are trying to uphold our rights. Is this a world in which we want to live it? Is this compatible with human dignity? The draft study raises this point, that dignity is important, but dignity, as you know, in the human rights movement has often been seen as an umbrella concept, which needs to be further developed. And here, maybe there is room for further development of this concept. Now, the idea that is mapped both in the draft study and also in the white paper is actually not so radical. Because if you see the ways in which regional systems, global systems, domestic systems have responded to the challenge of AI, many of them are actually on board on all of the points that we have made. I mean, there are regulations, there are already treaties out there, there are instruments out there that speak about access to AI systems, AI safety, data protection, non-discrimination, transparency, manipulation, automated decisions, accountability. This is already out there. So in a way, you could say that the framework that we are advocating, both the Commission and my team at Oxford, has been to some extent already accepted by states, by regions, by the global system, by global instruments. And we see this in places like the Council of Europe Framework Convention for Human Rights, which ticks some of these boxes, talks about dignity, talks about transparency, talks about accountability, etc. We have within the EU, we also have, sorry. Stuck. Okay, got it. So we have the AI Act that handles some of the issues that we are concerned about. For instance, manipulation is an issue that the AI Act deals with. And we have regional responses going back to the Malabo Convention that does address the issue of human decision-making, actually even before the GDPR dealt with it. We then have the GDPR, we have Convention 208 plus, another Council of Europe Convention, 108 plus, another Council of Europe Convention. We have the Continental AI Strategy that raises important issues concerning discrimination, digital divide, etc. And now we have the draft study that acknowledges many of the points which I raised. Even in faraway corners of the world, we are seeing some movement in that direction. So the United States, under the previous administration, has adopted a Bill of Rights, an AI Bill of Rights, that takes on 5 critical points to the scheme which I am also advocating, and I believe is also corroborated by the draft study: access to safe and effective systems, treatment of algorithmic discrimination, enhanced data privacy protection, notice and explanation with regard to non-transparent system, and a right to a human alternative. Of course, at this point in time, this Bill of Rights has been removed from the White House webpage. But it is still a very influential instrument, at least in North America. And there are other examples of countries that have adopted regulation that embraces some or all of the ideas that we have been discussing. And it's quite interesting to see that geographically, these systems are quite diverse. So this is not a set of ideas that is associated with one continent or with one region. We have some of these ideas in the Far East, some in Africa, some in Europe, some in North America. So in that regard, it's a very important development. Now, if everyone accepts this, then what are we doing here? And I would argue that there are a number of problems with what we have out there. I mean, what we have so far are mostly regulatory instruments that do not use the language of human rights. So the GDPR or the AI Act in Europe, these are classic examples of instruments that do provide, for instance, for protection against manipulation, or for privacy protection, or for a right to a human decision maker, but not in the language of human rights. They do not purport to be universal. They do not refer to human rights principles such as dignity or liberty. They don't often even use the language and structures of human rights. So the GDPR talks about the rights of data subjects, not about the rights of humans. I would say even the language of the GDPR is at some level dehumanizing, because we are treated not as human beings, but as data subjects, okay? And when you look closely at those regulations, I mean, the point is taken, but the protection is quite weak. So for the GDPR, for instance, and the right to human decision maker, it can be deviated almost at will, either through law or through a contract. This is not the kind of robust protection you expect to find in a human rights context. And even when you have language like the Framework Convention, the Council of Europe Framework Convention, which, although being a regional instrument, it is open to countries from other regions as well, I should say. But the language is extremely open-ended and general in ways that render it maybe not so useful and not so effective. So some treaties are, some instruments are too general, such as the Council of Europe framework, that basically says we should adopt measures to respect human dignity and individual autonomy. But this does not provide us with useful guidance as to what should be done. What should companies do? What should governments do? What should individual stakeholders claim? Or it is too, if you look at the AI Act, like I mentioned, it is really described in a technical way, which doesn't even mention what right do we have on the table. So it's either too specific or too general. And they also, of course, do not address, even when they do use the language of human rights, they do not engage some of the key problems that we have in this field for the application of human rights. And some of them were mentioned in the opening remarks by the commissioners, the private duty holder problem. How do we actually render these standards applicable to non-state actors? In this field, of course, of AI systems, states are often not the main generators of the abuses. They are actually sometimes simply bystanders. We need to go after the technology companies and hold them responsible to human rights standards. Digital divide and power gaps, which goes beyond the four corners of at least of some human rights treaties. I know that the African Charter, of course, is in a way has more richer reference to development-related rights. Who should undertake this process of adjustment? Do we want judges or commissioners in courts to develop the law, or do we also want maybe states to sign treaties eventually or to adopt legislation so there will be democratic legitimacy to some of these standards? Governments in this area, at the same time, they are often struggling to regulate, and we see many countries adopt a wait-and-see approach with regard to this issue. So any standard that we develop has to be cognizant of the power relations between states and companies, which is, as we know, quite difficult. There is this upstream-downstream problem. We are not seeing a lot of cases regarding AI systems in international and even local grievance mechanisms, partly because many of the harms are hard to capture. They're invisible or they're gradual, and maybe relying on the victims to bring cases is gonna only allow us to reform the system in a limited manner. Maybe here we have to go upstream. We have to actually go to the ways in these systems are modeled, the way they are designed, the way they are trained. This may be actually a more promising, at least in some areas, approach than the traditional human rights system, which is victim-centered. It has been very important and very useful in some areas, but in some areas it underperforms. And there are also conceptual questions about, do we see AI systems and the outputs of AI systems as a source of authority that is subject to human rights standards? I will, in the interest of time, will not go all the way philosophical on this issue. So this is my final slide. Our white paper from 2025, like I said, has been the product of 4 consultation sessions. The ultimate recommendation is that we should be interested in developing soft law standards. I think there was wide consensus among participating consultation that this is not the time to conduct a global treaty on the matter. This is not likely to succeed. But we do have precedents from other areas in the history of human rights law, starting from the Universal Declaration and moving on to the business and human rights framework. We're actually putting on paper in a soft law instrument more concrete normative expectations, had quite an impact in jump-starting political processes and legal processes. And in some cases, it also generated treaties and also domestic and regional regulation. So the recommendation is to go in that direction. I did notice that the draft study also contemplates a declaration as one possible output, although there is also some contemplation of a framework convention, which is also a very good idea. Though on a global scale, I don't know what can be done at this point in time. It's probably the jury is out on this question. The guidelines would both elaborate existing rights and consider also the development where needed of new human rights that would at least give expression to general principles such as dignity, liberty, equality, solidarity in the context of AI system. And then the paper does contain 7 rights, proposed rights. Again, some developed on existing rights, some going a bit beyond existing rights. It proposes the list. It also it discusses what should be the definition of those rights, what is their scope of application, and what would be relevant limitations to be brought on board. Of course, like all rights, these rights are largely relative. I think I will stop now, and I would be very interested to hear the panelists react to this paper and also to the draft study and to other ideas which are on the table. So thank you very much for your attention, and I look forward to hearing more comments. Thank you.
Thank you very much, Professor Shaney, for the presentation on the AI Bill of Rights, and Commissioner Durso for the overview of what the draft study addresses. So I'm going to welcome the panelists who are here with us in person, and also one panelist who is joining us online to have a conversation that is grounded on these 2 documents, but also addresses broadly what AI and human rights looks like on the continent. So if I may first welcome Honorable Commissioner Gersha Orvina Topsisono to the front. So Commissioner Topsisono is a prominent lawyer and human rights expert who serves as the Special Rapporteur on the freedom of expression and access to information in Africa. She's also the Vice Chairperson on the Working Group of Extractive Industries, the Environment, and Human Rights Violations in Africa, and a member of the Resolution Committee. And she also works with Commissioner Durso on the African Commission on the Study of AI and Human Rights that was discussed earlier today. And online, we have Professor Thompson Chengeta, who is a professor of international law and artificial intelligence technologies at Liverpool John Moores University. And he was recently appointed by the UN Secretary General to serve as the advisory body on disarmament matters. And Professor Thompson was part of the experts group that researched and drafted the first UN Human Rights Council report on automated weapon systems, which formed the basis of the current UN discussions on automated weapon systems. He also serves as the international law expert for the International Committee for Robots Arms Control and is the lead campaigner Africa for the campaign to stop killer robots. Professor Thompson also served as a consultant on the Commission's draft study on AI and human rights. And finally, in the room with us is also Dr. Johannes Ineo Ayalu, who is a postdoctoral fellow at 3 Generations of Digital Human Rights Project, which is funded by the European Research Council at the Faculty of Law at the Hebrew University, Jerusalem. And he's currently working on regional approaches to digital human rights, and his research interests span the areas of digital human rights law, and also third world approaches to international law. And his current research is also exploring regional approaches to AI governance, particularly with respect to the African continent. Dr. Ayalu, if I may also welcome you to the front. Yeah, of course. Okay. While I am preparing to ask the first questions in the room, if I may ask the technical team to also disconnect the screen. Commissioner Durso would like to address folks before they head back to the session, just so they can cover kind of areas that they would have addressed during the panel discussion. So Commissioner Durso, if you want to come up to the podium and address the folks in the room and online, and then we will proceed with the in-person and online panel conversation. Thank you.
Thank you very much, Salam. I thought that it would be good to just say one thing as we go into the discussion with respect to the development of the finalization of the study. So the version that you have seen may not be the final version that you would see when it is adopted, considered and adopted by the African Commission on Human and People's Rights. For a number of reasons, it would go through certain processes at the level of the Commission to make it fit for the standards and expectations of the African Commission on Human and People's Rights. But I think the most important aspects of identifying what the risks are for human and people's rights. Some of them are general risks that are common across the world. And there are some risks that are specific to Africa and African conditions and realities. And therefore, identifying and considering what those risks are is one important aspect of what this study would deal with. And the second one is the question of the extent to which the rights enshrined in the African Charter would be enough to cater for and address these risks. And of course, having regard to the question of the advantage and benefit that these technologies also bring for the realization and fulfillment of human and people's rights. So we will specifically look into the ways in which these different rights in the Charter actually are of such a nature that can meaningfully and effectively respond to these concerns, either individually or read together, given that some issues may require the reading of and the conjoinment of different rights in the Charter. And then the other thing that we would look at is what are those issues that can be addressed at a national level and therefore are amenable to regulation within the framework of the obligations of states, individual states, parties to the African Charter, and other related protocols to the African Charter. And what are those other issues that need to be addressed at different levels, whether at a regional level or at a global level. The questions of the kinds of remedies, redress that needs to be put in place. And then finally, we will ask the question of what kind of additional measures may actually be needed and required in order to have a more robust and meaningful response by the African human rights system. And that is where some of the questions that you have highlighted, Professor, relating to whether there will be a protocol that would address these issues based on the experience of the African Commission and the African human rights system in addressing emerging issues through protocols, or there would be soft law instruments that would be developed by the Commission building on what the study had identified. And there are already, of course, some relating to freedom of expression that Commissioner Grisha had already been doing through resolutions, for example, but much more broader and more comprehensive normative standard that may be required at the level of the African Commission that would feed into and complement some of the regional developments as well. Those are the kinds of things that, the final copy that the Commission would consider and adopt would take. I thought I clarified this as I once again thank you all for your attention and for the kind invitation, and we look forward to taking this conversation forward, and we do hope that you keep in touch with us, and we would be happy to accompany you in this journey. Thank you once again. I think Shangeta would do a great justice to the issues in the study. Thank you again. Have a good afternoon.
Thank you very much for those remarks, Commissioner Durso. So if I may start with the first question in the room to Commissioner Topsisono. If Africa's human rights institutions were to draft an African chapter building on the International AI Bill of Rights that was presented, what are the specific principles or rights that you believe should be included? And how would the regional particularities be included so that it can be grounded in African value systems and the historical and geopolitical considerations?
Thank you very much for that question. Actually, once we have the study adopted by the Commission, and I should draw your attention to Resolution 620, 630, and 631, which the Commission has passed. That is 620 on data harnessing, and also 630 on duty of platforms and human rights aspect, as well as 631 on the fact-checking aspects. Once these guidelines have been drawn up, we already have draft guidelines for 620, Resolution 620, which is on the Commission's website. Once these guidelines with the study are in place, then we want to consult broadly with all African states to see what they want from the guidelines as well as the study. And whether I do not think in Africa one size will fit it all. So we'll see whether northern, southern, eastern, and western states will want different things. Whether I do not think that draft AI Bill of Rights would fit in Africa. So each region has its own specificities. So I think that then we present these to the state parties and see what they want from that. It's most probably likely to be soft law instruments in the first place, and then we might graduate. As Professor has stated, these AI and other technologies are moving so fast that we cannot have a bill at this stage. We need to have soft law instruments that can be developed as we see other emerging technologies coming through, because having something that is too rigid doesn't work, in my opinion, at this point in time. So this is what we think will happen, and by next year, around this time or a bit October session, we hope that we'll have all the guidelines and the study in place and present these to African states to see what they want from there. I have to also state that I think that states do not know how to react to these emerging technologies right now. This is why I think draft guidelines just help them to see what are the problems that are being posed so that they then react accordingly. Thank you.
Thank you very much, Commissioner, for highlighting the current state of the continent, but also what to anticipate in the coming future. If I may move online to Professor Chengeta, the white paper focuses on human rights risks as it pertains to civilian applications, but your work does focus on autonomous weapon systems, and I wanted to get your thoughts on how you see the proposed AI Bill of Rights serving as a foundation for governance for autonomous weapons, and what kind of specific considerations need to be taken into account to address the challenges within those specific domains.
Thank you very much for the question, and thank you to the organizers for this side event. To answer that question, the first foundation that I have to mention, which is important, I think, both within the study of the African Commission and also highlighted in the white paper, is that human rights, or human rights law to say, must be at the foundation of regulation or governance of artificial intelligence technologies. Now, the important part to that question, which I will then add, is that the separation between artificial intelligence in the civilian domain and artificial intelligence in the military domain may not be necessarily appropriate or important when approaching of AI governance from a human rights perspective. And I'll say two reasons why. Number one, if you look at the African Commission's approach, at least as a human rights institution on the African continent, starting with, for example, General Comment 3 on the right to life, or Article 4 on the right to life of the African Charter, already in that general comment, the commissioners were addressing both issues of technology within the civilian and within the military domain. The reason being, if harm or risk is caused or is emanating whether from the military or civilian domain, that separation is not necessarily important. It is the impact to human rights that is having. Number two, if you look at Resolution 473, which Commissioner Deso was mentioning, again, it particularly again deals with both the risks in the context of civilian domain and in the military domain, and which is also the approach in the study. If it was at the international level, you see again the same approach being taken, say, in the UN Human Rights Council, studying or actually putting out a study on the question of human rights implications in the military domain. Now, if you are trying to come up with important rules and regulations which are grounded in human rights as far as AI is concerned, worrying much or trying to say you want to have, I don't want to call it a piecemeal approach, to say we focus first on AI in the military, in the civilian domain, and say rules from there, how can they help in AI in the military domain, which are autonomous weapon systems, which are referring to. That may not be a helpful approach, precisely for the following reasons. At the international level, or when dealing with, say, international states, sometimes there is an approach that seems to suggest, if you're discussing AI in the military domain, you hear, if you mention human rights, they say, we do not want to deal with that because human rights institutions have to deal with that, with the question of human rights. And if now we are in the human rights domain, African Commission and other institutions which are dealing with human rights, if you were to separate again to say civilian and then military, I'm not sure that that would be a very helpful approach to do. The issue, if I were to give an example of the white paper and what is in the African Commission study, say, for example, the white paper is dealing with the right to non-discrimination, which is an important right, and the white paper do really an excellent work on that. The same issue or the same aspect of discrimination, that is prohibited discrimination, adverse discrimination, also arise in the context of armed conflict, albeit other rules applying there. So I would say, basically, it shouldn't be a question of sequencing as to what is learned in the civilian domain, how will it help? Because to some extent, they are so interrelated. The question should be thematically, if I'm dealing with the right to non-discrimination, how does it operate within the civilian and within the military domain, and how do we approach that? If it's the right to life and the same approach, I would want to just end there to say, for me, it is the doctrinal approach to the question which you're asking, which I would say I wouldn't sequence them like that, as actually perhaps the approach would be to approach them doctrinally.
Thank you very much, Professor, for essentially reframing what the question is asking and trying to see how these human rights issues that the white paper addresses arise not only within civilian domains, but also it permeates through other spaces such as the military domain as well. If I may come back to the room to Dr. Ayalio, reflecting on your work on how international human rights-based approaches could potentially marginalize perspectives within the global majority or what we call the global south, how do you think we can propose an African approach to an AI Bill of Rights, both in terms of how the rights are conceptualized, but also to account for the lived and experienced realities within the continent?
Thank you, Salam, for that great question. First of all, I would like to acknowledge both the draft study and the white paper authors, and congratulate for terrific work, because globally we only have few very little instruments about that that's developing in Europe. So I think this is something that is much needed both in Africa and more generally around the globe. So to your question, I think I would like to say two things. First, normatively, we need to kind of anchor, to issues about African conceptions of human rights, like the communal conception of human rights centered on people's rights, or like duties that most of us now in the African human rights system, especially the African Charter, basically embraces this idea of communal conception of human rights that's articulated, let's say, on duties from Article 27 to 29. So these normative instruments and normative provisions help us, ground the African approach to AI governance. Practically speaking, I would like to make, I think, 3 or 4 points briefly. So the first consideration is epistemic consideration. That means like in the development of AI, or like from design to decommissioning, most of the time the knowledge system we usually try to discuss is mostly Anglo-American, I would say, or Eurocentric. So in that context, like we need to also push to include or incorporate voices from the global majority, including Africa. So we need to ask ourselves how the knowledge system is applied in the entire life cycle of AI system, from design to decommissioning. So I think this is something we need to ask collectively. In this regard, I would like to mention a book by Professor Clapperton Mafunga. He wrote a book, What Do Science and Technology and Innovation Mean from Africa? And in that book, he argues that our definitions of science, technology, and innovation originates from countries and cultures that have acquired their dominance of others through global empire, mainly militarily, capital, and media, even wants to impose upon those without such power of their definitions. So that means like, the whole system, the whole discussion is centered on a Eurocentric articulation of, AI. So the knowledge system that is excluded in this discussion will be left out at the end of the day. So we'll become, simply observers or like recipients of when these systems are evolving. That said, I think about epistemic considerations, we need to kind of, embrace African agency or knowledge system into these AI discussions. And the second point is Commissioner Tom Sono earlier highlighted about native languages. So there are also linguistic considerations we need to kind of advocate, like during these AI systems. Like in Africa, we do have over 2,000 languages with conservative estimates. So the whole system of this social media content moderation as well as AI companies are mostly trained in, high resource languages. Even those African high resource languages like Arabic or Swahili or Amharic or other languages in Africa are yet to be like fully integrated in the training of data sets. So we need to advocate that as well. And the other consideration might be cultural and social considerations. I also highlighted with the knowledge system. So this one is something like we have a way of life that's, uniquely African or uniquely communal. So in that regard, I think we need to kind of, foreground such cultural and social style of life into AI discussions or, AI discourses as well. Finally, maybe as, a way forward, I think we need to also kind of advocate for decolonial approaches to, AI systems. Recently, like the global system, the Global Center on AI Governance also invited African experts to discuss about the submission on the UN General Assembly. So in that discussion, most of the experts, highlighted, this African approach to AI governance through decolonial approach, because this decolonial approach help us understand to kind of make platforms accountable, especially many of the actors are not states in this domain. They are private companies, as Professor Yuval also touched earlier. So in that regard, we need to kind of advocate this decolonial approach as well. Thank you.
Thank you very much for responding to that from a multi-pronged perspective, both from like the epistemic and ontological perspectives of what artificial intelligence and human rights mean, and also the practical challenges and highlighting Muhunga and others' work on thinking of Africans as scientists and innovators. I'm going to go back online to Professor Chengeta to ask about one issue that was brought up several times today, which is the issue of accountability with respect to AI. And in your work, you have highlighted that establishing meaningful human control is one of the ways in which we can tackle this with respect to AI. And how can this be expanded to go beyond the individual in order to address African people's rights? And also, on the global stage, what is given Africa's position, what kinds of international relation discussions need to be taken into account when addressing this?
Thank you again for the question. I'll start by mentioning also that the question of meaningful human control, a term which was coined by an NGO, I think, called Article 36 in the United Kingdom, some way back, I think it was in 2012, if I'm not mistaken, has gathered a lot of lasting discussion as to what it means when it comes to governance of artificial intelligence technologies. And that term, I should say that within the African Commission itself, the literature of the African Commission, General Comment number 3, in fact, is one of the first general comment to say it should be an anchor in terms of human rights and governance of artificial intelligence technology or emerging technologies, the idea of maintaining human control. And the basis for this, to explain it further, is to say that when we talk about the question of responsibility, especially under human rights law, I think we ought to fully explore and understand how responsibility works when it comes to human rights. Of course, as I think it's common cause, that the primary obligations as far as human rights is concerned rest with the state, the obligation to respect, to protect, and to fulfill human rights. These are the obligations which you find both at the regional level and at the international level. There is rich jurisprudence in human rights law as to what the obligation, the state obligation to protect, to fulfill, and respect human rights mean. Now, I think it is important, I think in the study it is also highlighted, to then try and understand in the life cycle of artificial intelligence technologies, be it in the civilian or in the military domain, what do these standards mean? The obligation, the state obligation to protect, respect, and fulfill human rights. And we need that language to remain, especially when we're talking about governance and responsibility. Now, as I said, for many human rights institutions or initiatives across the globe, what is generally accepted is that responsibility rests with the state. But within the unique, this is, I think, where Commissioner Deso was saying, there are certain aspects which are in the African Charter that are important and very unique to the African Charter. The African Charter does not only have state responsibility, it actually also have individual duties, something that is only in the African Charter and Human People's Rights. This study actually elaborates on that to say, when we're talking about these individual duties, which can then also be extended to non-natural persons, in other words, legal persons, what are those duties as listed in the African Charter, and how can they be, for example, interpreted when we're dealing with AI obligations? So my point, which I would emphasize, is that when we're talking about responsibility, especially from human rights perspective, we are talking about the question of the right to a remedy, which is a recognized right. To say where there is a violation of human right, a person is entitled to a remedy. And if you are employing AI technologies, particularly those that may have autonomy to the extent that you are not able to trace the person responsible for violating the right, whether the state or the individual, you are having an accountability gap that must not be tolerated, at least from a human rights perspective. So which means if a state at a community level or at an international level, we are trying to say, how do we maintain that right to a remedy, which is linked to responsibility? It means the accountability chain in the entire cycle of the life cycle of an AI system must be maintained. So the discussion is huge. People have got great ideas, but for me, I will always ask the question, the bottom line, whatever you are suggesting, does it maintain that chain of responsibility to which I can link it back to the responsibilities of a state or to the responsibilities of individuals if we're talking about the African Charter? That's what I would want to say regarding the question of meaningful human control. By the way, I love that African states at the international level most use that term. Many people use that term to say maintaining meaningful human control is simply saying maintain the human to be accountable for any actions that affect or that have far-reaching consequences for other human beings. As to what that term means, some of us have tried to come up with definitions of what it means, or the formulae which you can come to that. I do not think that perhaps, because people say, well, we can disagree as to what that meant, other actually call it meaningful human involvement. And I always say it's not about the name. It is about the question of maintaining what is important. And from a human rights perspective, what is important is that there is a right to a remedy. And a right to a remedy depends on certain aspects of responsibility of a state or responsibility of an individual that must be maintained.
Thank you very much for the response and trying to center what redress and remedy requires, which is a sense of responsibility, regardless of how we frame it. Coming back to the room to Dr. Ayelio, some of the work that you've done quite recently addresses the human right to informational self-determination. And I will invite you to introduce what that concept is. But I also we're hoping if you could expand on what that looks like, both on individual and also collective levels, and how can an international bill be adapted to Africa's regional context to protect this autonomy, and particularly with respect to democratic processes in Africa.
Thank you, Salam. That's a bit tough question to answer. So actually, like when we see this right to informational self-determination, I think it's evolved from the European data protection rules, but very recently also the Inter-American Court and the Inter-American Commission have acknowledged this standalone human right to informational self-determination. Professor Shani and I wrote an article about the right to informational self-determination and what that does mean in the age of AI and digital technologies. And we found that in that regard, I think the AI systems, especially when they are applied in the context of surveillance, one is AI captures our data. It will be super difficult to kind of remove or suppress our personal data. So basically the idea of informational self-determination, both at individual and collective level, enables us to what extent our data, our personal data, can be used by private and public bodies. Right. So in that regard, in the case of Qajar versus Colombia, the Colombian authorities were spied against a civil society called Qajar, and they taken their personal information, their whereabouts, and their lawful operations. And then this civil society brought a case before the Inter-American Court, and the Inter-American Court ruled that surveilling members of the Qajar would violate a standalone right to informational self-determination. So applied to in the AI context, especially authorities in various countries use AI for surveillance purposes. In that regard, it's hard. One is the data sets are trained in our personal data, or once they capture it, it's hard to remove. And in this regard, I think Judge Rodrigo Mudrovic commented that the use of AI would further enhance the power of surveillance authorities, allowing them to access a vast amount of data. So that means like the challenge is huge. Like in the past, like during when the digital age was propping up, like there is this claim, this urge that the internet never forgets. But that urge is now, something worse in the age of AI, even worse. So that means like in the age of AI, like removing our personal data would be hard, even if we have the right to be informational self-determination or under data protection law, we have the right to be forgotten. Still, once our data is stored in AI systems, it's hard to forget. So in that regard, I think it affects our individual rights, both individually as well as collectively. I think that's the question I want to answer. So is there any other?
If you would like to speak to how this affects democratic processes in Africa.
Well, I think, from the judgment and from these emerging standards, like, this would ultimately affect if surveillance authorities, continue to rely on our personal data through, like, various techniques of surveillance enabled by AI. I think that would definitely affect freedom of participation, the right to freedom of expression, the right to privacy, most importantly. So in that regard, I think it will definitely affect democratic processes as well.
Thank you for responding to the second half, and also for underscoring how the permanent ink, as we used to call it, of the internet kind of now bleeds into different spaces and affects a myriad of different issues. So if I may go back online with Professor Tengeta to ask, in terms of AI-enabled surveillance, which was just discussed by Dr. Aiello, and biometric identification, as well as platform dominance, what kind of AI-specific rights do you think that African human rights bodies and advocates should urgently address? I believe that there were several rights that were mentioned both by you and your fellow panelists, but what stands out as kind of particularly urgent right now to you in Africa?
Thank you once again for the question. I would start by acknowledging the comment that was also made by Honorable Commissioner that perhaps also there is, when you look at specific continents, there are specific issues that are important to each continent or to each community. That's the first thing that I would want to say there. Then the second aspect that I would want to mention in relation to the question you've asked me is the idea of indivisibility of human rights, that human rights are indivisible. So usually when I'm asked the question, which right do you think is more important? I have a bit of a difficulty because they are interrelated, they're interdependent for you to be able to separate them, especially when you're dealing with an emerging technology like artificial intelligence. The approach, which, for example, the African Commission was taking in its study, where, for example, looking at the generations of rights that are there, social, economic rights, civil and political rights, and collective rights, and how these rights interact with artificial intelligence, made sense to me. Number one, because if you look at social economic rights, given the continent's needs in terms of development, in terms of social economic rights, those are important rights. You can never be able to separate them. But there are equally also other civil and political rights that are intertwined with those social economic rights that you cannot separate them. There are also collective rights, and I'll give examples. If you're talking about economic development in AI, right to health, there's question of non-discrimination, which is a civil and political right. You can't separate those because there are issues that are intertwined. If you look at the right to dignity, I know Professor Eva was mentioning to say sometimes, the right to, if you say right to dignity, it almost sounds like a conversation stopper as to what it means. And I hear this argument sometimes at the international level, and my response is to that is to say that I don't think it's that controversial, at least on the African continent. That's why you see, particularly Article 5 of the African Charter, it is provided as a right, as a standalone right. If you look in other constitutions, in other human rights instruments, it's not a standalone right. But the African continent, because of its history with indignity that has been suffered by its people, that is an important right that stands alone, that the interpretation of how, when I'm saying what is the impact of artificial intelligence on the rights of human beings on the African continent, dignity for me actually becomes, really a highlighted point there. There are also other important rights, or the third one, which I would want to mention, which is the question of the right to non-exploitation, which is part of collective rights in the African Charter. So if you look at the developmental stage, how data is collected, how resources are collected for the development of hardware of artificial intelligence, the software of artificial intelligence through data. There's a lot of exploitation that happens there. What others have been referring to as data colonialism, for example. So if you're looking from a continent that is trying to still find its feet in terms of being at equal standing with other global nations or powerful nations, right to non-exploitation becomes very important. Now, regarding the rights that have been mentioned by Prof. Yoval in the end of the slide, if those are the ones you asking me, I think I've had the pleasure of being invited to Prof. Yuval's really, really outstanding consultations at Oxford, University of Pretoria, and fantastic work of that project, which I really, really, really have learned a lot from that project. The only perhaps, which I would say difference is in our view, or in my view, in participation of the African Commission study, I'm not sure if we can have what we call standalone rights related to AI, where you'd say AI right to this and that. There is a reasoning perhaps behind that, especially with discussions within the consultations of the African Commission, why that perhaps may pose a number of difficulties. But dealing with the rights that are already provided in the African Charter, for example, which are elaborate in many ways, there is certain things which you think, well, we may need clarifications here, but those clarifications can come as perhaps declarations, as additional protocols, but not necessarily as saying we're introducing new rights. These are the rights that we think we focus on when it comes to artificial intelligence. But the approach being, be comprehensive. All rights matter, indivisibility of rights, and their interdependence, and try to see the mechanisms that is existing. This is why I agree also with Prof. Yuval. There are certain gaps. There is a lacuna that is there, where we can say the system lacks something. But that which is lacking in terms of what we suggest, my suggestion wouldn't be to say there is need for creation of new rights, not necessarily. There is something else that is needed, regulation to strengthen these existing rights or to provide interpretive mechanisms that are binding for these rights which are already in existence to work. That would be my approach. I wouldn't suggest that there are certain particular rights I would say are privileged, but rather to have a comprehensive and holistic approach to this.
Thank you very much. I do want to give other folks a chance to ask questions, both in the room and online. So if folks online could either indicate in the chat or by raising their hands, and in the room, we can start with raising hands and we can have a roving mic as well.
Hello, good afternoon. My name is Mahmoud Diallo. I'm from here in the Gambia. I work with a civil society organization. Professor, during your speech, you rightly said that like AI is advancing very rapidly, and countries are trying to catch up. That is especially true for Africa. Now, the question is, there is lack of capacity in Africa, especially with human rights organizations in trying to help the citizenry. So what training opportunities would the international organizations or institutions provide for African human rights organizations so that they'll be equipped to help the people that they serve? Thank you so much.
No, thank you. This was a very good question and a very and you're absolutely right. We do have a problem of not only political action but also capacity, awareness raising, and ultimately resources that would enable civil society to weigh in. Currently, it's really not a fair competition because you have these mega companies that if they were, I mean, if the top 10 companies in technology would have been a state, they would have more resources than every state in the world except the United States and China. So they will be the third largest state in the world, only the top 10. So when you have this amount of resources and you have, on the ground, civil society groups, it's not going to develop. There needs to be collaboration across regions in order for this to happen. I think the one element that is working in the African region, perhaps a bit better than in other regions, is that in other contexts, I think there is some reluctance in the United States, for instance, there is reluctance to regulate because they see it as something that would slow down the innovation and would slow down the money stream that is boosting the economy. I don't think that for countries in the global south or the global majority, I don't think that this calculus actually works. So in Africa, and I think also in Southeast Asia, there is a much more favorable climate towards regulation because you see that regulation and introduction of human rights standards will really protect the individuals. And there is no business side. I mean, there's no strong business argument going in the other direction like you have in the other regions, which I would also challenge. I think even for the United States, it's a bad idea not to introduce human rights. But there you have at least this administration very hostile to any form of regulation. And I think in the African continent, there is greater ripeness to have a serious conversation about regulation.
Good afternoon. My name is Lakshita. I would want to congratulate the Center for Human Rights first with all the partners together for this work. I think it's a timely conversation and a lot of institution, I should say, that maybe, we don't really have capacity to have this kind of conversation because how technology as well is really moving at fast pace. And so in terms of trying to catch up with how things are evolving, one comment and then one question. I have been stepping out of the room. I don't know if it has really been addressed. One comment is I had a lot of Africanization, decolonial approach when we're speaking about the African human rights system. I would just want to draw a line of caution because when we are trying to also, I think Africa is a continent that we are grappling with African values. And when we speak about human rights, it's more contested. So when we are trying to say that we need to frame kind of language or terms in terms of the African perspective, it's important, yes, but we need to be very careful. That's just the line of caution I want to say, because we've been receiving documents from the African Commission about African values, and it's very regressive, unfortunately, in the human rights space. So this is the thing that we need to be careful. Because when we are trying to speak about Africanizing, we look at the diversity of the continent and who are we considering in the room when we are speaking this language. Secondly, as litigants now, what's the future of AI when we bring cases before the African Commission? We are not throwing shades or we are not attacking, but as people who use AI, we know which language is AI or which language is really coming from certain decisions, right? And we can see certain decisions have language of AI. And unfortunately, if, for example, we're speaking about women's rights, AI does not go to the substantive matter if you don't know how to play with it. I think those who use AI, they will understand that you can ask to generate decision, but then it might actually miss out things, right? And also in compliance with the African Charter, for example, as panelists have been speaking. So what does AI mean in terms of litigation, in terms of communication that we receive from the mechanism, and here today we are the African Commission. In terms of compliance, are we also trying to say that there needs to have a disclosure than when we are releasing judgment, that this part of the judgment have been assisted by AI tools? That's it. Because also even in treaty mechanism and soft laws, we could see documents moving from 150 pages to 11 pages within a year. In treaties, and it really lacked a lot of substance. And we could have done a comparison, right? We ask AI to draft a convention for us, and it can give us the same thing, right? And you realize that this document does not meet the decision that was adopted for this to come. The same for the declaration we are working right now. It has moved from 8 pages to 46 pages, which does not address the work that it was supposed to do when it was called on for the resolution. So just in terms of the compliance of AI adoption in the work of human rights, because we don't want to receive regressive documents or decisions at the end of the day as litigants, because that's very important for us when we bring cases or we engage with the African human rights system. Thank you.
Thank you so much for that intervention. Before we go to the next question, if any of the panelists or Professor Rival, if you want to respond to that intervention, I want to welcome that, and then we can move on to the next question in the room.
Thank you for the intervention. It was really excellent. And on the African values, I agree that one has to use them, but one has to use them in caution. I would argue that with regard to AI technology, this idea that we heard also from the commissioners about a community-centered approach is actually very important in this context, because a lot of the harms, for instance, what is sometimes called contamination of the informational ecosystem, are actually felt at a community level much more significantly than at an individual level. And also this idea of duties, especially for powerful actors. These are areas where the African charter and the African system is more advanced, I would say, than the other systems. And the point of departure is better. So I would certainly encourage using this. But of course, like we know that every doctrine and every special consideration could also backfire. So that's a very good point. And on decisions, this is a serious issue. I think we are still at a point, also at the university where I work. I mean, the question of where do you draw the line is I think is being shaped, and I think a human rights approach, for instance, a right to human decision, right to transparency. In some regulation, we have demands. I mean, even Italy has just passed law that does allow judges to use AI, provided that the judge remains responsible for of course, every part of the decision. So these elements must be put in place, and I think it's very important that civil society push back against imprudent and excessive use of AI, especially we are trying to preserve the human-centered nature of the system, and if this is going to be also delegated to AI, it's going to be very tragic.
Hello, everyone. Thank you so much for the presentation. I love the question that you asked about how do we then Africanize AI and make it to reflect our values, our cultures. I totally understand your argument on values, because sometimes it feels like we're regressing in the name of our African values instead of being like human rights based, approach based. But I just wanted to ask, because I've heard Professor Chengeta speak about not creating more rights and just dealing with the rights that we already have, and maybe even the interpretation. So I wanted to ask in terms of women's digital harms and AI harms that specifically target women or disproportionately target women, like deepfake, for instance, like AI algorithms, how they profile women and affect women's access to credit, and even now with the African Continental Free Trade area coming up where women do digital trade, how do we then use the existing protocols like the Maputo protocols to ensure that women, especially African women, are protected from that? I mean, I have to say that sometimes when I do a voice note and I talk to ChatGPT, it doesn't hear me at all. I was like, this thing is trained in European, accents because it doesn't hear me because I have this thick African accent, which sometimes can feel like, okay, so then how do we then bring it to Africa in a way that is like human rights based approach, but not like necessarily regressing in the name of our values, our culture. So thank you.
Thank you. Professor Chengata, were you able to hear the question or would you like us to reiterate it?
Yes, I think I heard the questions. And I would want to start by just acknowledging the importance of both the questions, I think, and comment that was made by also the other participant. And to say that I don't think there are easy answers to these questions, but this is what I would say. My first approach, if I'm saying my first point, would be to say that the reference to African values is more fully invoked when people are talking about African ethics. Are there some difficulties in trying to say what are those values? Because Africa is not homogeneous, to say there are various communities. Yes, there are those difficulties, but are there other commonalities that are very, very important that tie together the African continent? I believe there are. Article 17 of the African Charter itself on Human People's Rights acknowledges this. And I wouldn't want, as a starting point, to ever take it as a simple point to say, well, some of the African values will take us backwards. When we have that conversation, the invitation which I will have to anyone who say that is usually sometimes it helps for the conversation to move the conversation to give specific examples of those African values. Because most of the time you hear a comment that says African values are regressive, especially in the conversation of AI. I would want to hear which one specifically. I'm not sure there are, I don't want to minimize that there could be people who are advocating for values that perhaps may not be in the interest of various African communities. That should never be supported. But if you are talking of African values of togetherness, Ubuntu, the questions of non-domination, those are the values that underpins the African Charter. And when we're dealing with questions of how do we regulate or how do we approach the idea of artificial intelligence and how it's being, because most of it, the greater part of it is being exported to the continent, those are values which we cannot afford to ignore. Sometimes, I'm not saying this is what is happening, there is a challenge where there becomes a conflation of a number of issues where there are disagreements, and justifiably so, in terms of what is the value which we are taking on this particular issue. Those disagreements, I'm not sure if it will be productive to wholesomely transfer them to the discussion of artificial intelligence technologies. And the example which has been given by the second speaker of the Maputo Protocol and other protocols or soft laws that deals with women's rights, very, very important. If you look in the study of the African Commission, I think it starts by acknowledging the various architecture and laws that exist on the African continent. And we acknowledge that one of the major problems that arise is implementation. That these are not implemented. The problem of implementation, for me, the problem of implementation should not be taken to mean that perhaps these values or these issues are not important. So that would be my general comment on that, to say, regarding anything that is harmful to anyone, regardless of which group, that should never be adopted. And when we are problematizing that, sometimes I think it's helpful then to pinpoint which exactly harmful value you are referring to, and where, for example, it's being put into the conversation as part of governance of AI. Reason for doing that it means we become on the same page, we start talking the same language, we start talking of the same issues. Because sometimes the era, or not the era, I don't want to call it a mistake, the pitfall that we sometimes fall into is if we continuously generalize points of simply saying, say, for example, that African values are aggressive, that's the point that usually is raised even at the international level, which leads to that epistemic injustice as to whose knowledge matter in terms of these things. Because we have statements which will be saying, yes, we actually doubt African values. Which ones in particular in this discussion are you referring to? That specificity is important. And for example, if in the room there are those specificity, which we can say, these are some of the African values that have been put to table regarding AI governance. We discuss them and we actually then come to an agreement. We're not talking about this. But if we have those generalized comments, what it help do sometimes, because there's also a global conversation on governance of AI, it creates that, or it almost creates those echo chambers of saying, well, the African values are problematic, but which ones have been specifically involved in the AI governance, which we're saying are problematic? That's again where I would want to end on that point.
Thank you. I believe we have one more question in the room, and then we can give panelists a chance to kind of have closing remarks or anywhere where folks can follow their work.
Okay, good afternoon, everyone. I'm speaking from the perspective of a victim because we know AI is being programmed to do some stuff that like can ease the burden. But now at the stage where I stand, it's like if our case is being written on AI in terms of judgment and other things, how protected are we from our perpetrators? Because we know as a victim, our life are always in danger whenever we go around areas where our perpetrators are. So like if AI is being used to interpret the act or the scene of what happened, how sure are we that they can't access it or other people can't access it for them to know that, yes, indeed, we were the one that lodged the complaint? So I just want to know how protected are we?
Does anyone in particular on the panel want to respond to this before we pass the mic?
I would like to say a few words. So I think the AI companies are, quite opaque in their process, and we don't know how they, process, such kind of requests. Recently, I heard OpenAI has started kind of an advisory group that monitors like such kinds of, incidents or like, victimhood situations. So even in the presentation, we have seen like how these AI systems are opaque in their process. I hope Yuval would add some points on this. So I think the whole system, we need to ask about transparency and accountability, but still their standard, their community and policy standards are quite vague and general. So it's hard to answer as well. Thank you.
If the MC, with your allowance, I can just add one sentence to that.
Sure, go ahead.
Okay. First, to the memo last spoke, just to acknowledge that very, very important point from the victim side. I would add to what Johannes just said. I think a very important point, which is actually articulated. I would just also add that it boils down to also that question of trust. What is the trust between those who become victims of these technologies and those who are in the custody of that particular technology? And of course, you may have had, I think, from the global knowledge, there are terminologies which are used, such as trustworthy AI. It's because the issue of trust is very big. Now, the challenge which becomes very acute on the African continent is that the powerful AI technologies that are then used by government institutions, majority of them are not African-made. Control of any end back as to what is happening with that technology is not necessarily with our governments. And so you raise a very, very big and legitimate issue to say for those, for example, who trust their data within governments, institutions, and that data is being dealt with an AI technology that is actually not really originating or actually born on the continent or in that community. What trust can you have with that technology? And in terms of governance, then it becomes an important part for those who are responsible to address this issue of trust, to say these technologies we are deploying in our communities, who is in control, adding to the questions of transparency, which just Johannes just mentioned. Thank you very much.
I agree with everything. Thank you for your question. It's a very, very important question. And I think part of the disruptive effect of AI is that the use of AI would require new protocols for data protection. We cannot assume that the way we secured information in paper files or even in computer files without AI would give us the same amount of protection. So I don't want to worry you, but it's important that institutions like the African Commission, but also national courts and police systems that are using AI, and it's good that they're using AI because AI has a lot of advantages. It can speed up, even the processing of cases, which for victims is extremely important. But there must be, we cannot assume business as usual. We need to develop new and suitable protocols to ensure that privacy and other safeguards are in place. Thank you.
Thank you. While the mic is still right there, if we can have kind of closing notes and how folks can continue to engage with the Bill of Rights, the white paper, and also other engagements, then we can also see the folks online off and kind of communicate here on what kind of, what our exit plan is. Thanks.
So from my side, again, thanks to all of you who have been patient and engaged, and also thank to the other participants and sponsors. This has been a great opportunity for us to engage with the African system, which is, like I said, a system with, in this regard, a particularly interesting and important system, given the flexibility of the charter and the history of being proactive in developing standards. So I hope this would continue. We are continuing our collaboration with the Human Rights Center, with the Global Center for AI Governance, with Oxford, with my research project on the 3 generations. We're going to have another African event soon in Addis Ababa, where we will present the ideas and hopefully engage maybe also with the AU institutions there. And we are planning on the Oxford side to have an AI and human rights summit in early October, where we will bring stakeholders and experts from the different systems, the different regionals and global systems to discuss how to move the dial forward. But it's going to take time. It's although we don't have time, it's going to take time. Thank you.
Henok, do you want to come to the front to communicate to the folks in the room where to go next?
Hello, once again, thank you for coming. So we have lunch upstairs in the second building. So you have coupons. Everybody has coupons, right? Yeah, we can go even together. We can use the lift. Yeah. Thanks.
Thank you for that. And thank you for those online who joined us and stayed all the way through, particularly Professor Chengeta. And thank you everyone for coming. Have a lovely rest of your day.
If you don't mind, we'd just like to kindly get a quick picture before everyone speeds up.